Hello guys, welcome to our channel. Today in this video, we will discuss what Jeremy Hogan revealed about SEC versus Ripple lawsuit. But before we start, make sure to give this video a big thumbs up, and if you are new to the channel, don't forget to subscribe before leaving. Also, hit that bell icon so that you can get notified whenever we will upload a new video. For now, let's get back to the video straight away.
Want to win an iPhone 12, maybe a MacBook Pro? How about $500 cash? You decide. All you have to do is comment the secret hidden message somewhere in this video, and leave a like on this video and subscribe to the channel so we can keep affording these giveaways.
The future of cryptocurrency and blockchain technology could well be decided by a lawsuit filed at the end of 2020. On December 22nd, 2020, the SEC filed a lawsuit against Ripple Labs and two of its executives. The claim is that they traded $1.3 billion in their cryptocurrency XRP as a security without registering it with the SEC. Ripple and other parties have since countered with claims that the SEC is biased in its assessment. As of right now, here is the current status of this lawsuit, as well as a breakdown of each side of the argument. The SEC's claims. In their legal action made at the end of last December, the SEC claimed that XRP is classifiable as a security because it was used to finance Ripple's platform, which facilitates money transfers for retailers. In the process, the platform's executives were also enriched with the sales of XRP. Under SEC regulations, securities must be registered with the Commission, and certain financial information must be publicly disclosed. The goal is to counteract fraud and safeguard the interest of investors. When determining whether a virtual currency counts as a security, the Commission applies the Howey test, based on the Supreme Court ruling on SEC versus W.J. Howey Company in 1946. The test is that if an asset is sold with the expectations of profits derived from other parties' efforts, then it counts as a security. As the SEC currently defines XRP in their lawsuit, it would pass the Howey test. Ripple's response. Most companies targeted by the SEC in this manner settle. That's not the case with Ripple, however. Rather than comply with the SEC's demands, they have decided to fight it. Why? They claim the SEC has been biased in how it applies the definition of security to virtual currencies. If this is proven to be accurate, it would undermine the Commission's authority, not to mention tarnish the credibility of their case. In particular, Ripple has pointed to some of the associations that members of the SEC have had with other crypto platforms, especially Ethereum. While there is still little evidence of these ties, the fact that the Commission gave Ethereum a pass on securities regulation while attacking XRP does appear suspect. This is especially so since Ethereum initially funded its operations with an ICO, which would absolutely be considered a security. The SEC has claimed that Ethereum currently operates in a decentralized manner, which disqualifies it from securities regulations. But if that's the case, Ripple questions why XRP is being attacked. Worth noting is that Ripple was initially financed by venture capital, not an ICO, and now claims its operations are not materially different from those of Ethereum. In addition to all this, Ripple is claiming they had no fair notice that what they were doing violated securities law. However, the SEC has recently admitted that no statement was made on whether XRP could be classified as security before filing its case. To sum up the positions, the SEC claims Ripple was selling XRP as an unregistered security. In addition, they point to its role in funding Ripple and claim Ripple's platform is not decentralized. Ripple claims the SEC is making classifications based on bias rather than actual merit or even well-defined rules. They claim their operations are not materially distinct from those of other platforms that may have been given a pass. The lawsuit is still in its discovery phase, meaning each side is gathering evidence to strengthen their individual claims. Odds are, it will be years before we see a definitive result. Why is this important? Why is all this so important to the future of crypto? Currently, many virtual currencies are regulated through CFTC regulations, which are far less heavy-handed than the rules applied by the SEC. If the SEC wins, they'd have regulatory oversight over many virtual currencies being traded today. There's a good chance that this extra oversight could stifle the technology's development in the US since it was built with the design of being independent of heavy government regulations. Other countries would likely lead out on its own development. On the other hand, if Ripple wins, then the CFTC's lighter regulations would likely apply, and blockchain technology would be freer to develop further. A potential downside would be a lack of legal safeguards against criminal activity, though many state that the potential for something to be used in a crime doesn't justify regulating honest use. What does the future hold? It remains to be seen. The SEC versus Ripple case has a long and likely messy process of courtroom litigation ahead of it, and we're all watching to see what will result. The Securities and Exchange Commission has filed a letter of supplemental authority in support of its motion to strike Ripple's fourth affirmative defense, the fair notice argument. The plaintiff has brought to the court a December 20th, 2021 ruling on a Northern District of Illinois court denying the defendant's motion to dismiss the SEC versus Fife. According to the letter, the Fife defendants contended they did not have fair notice of the SEC's novel interpretation of the statutory term dealer, binding authority on investment contract since 1946. The court stood by the SEC as it agreed that for the purposes of assessing fair notice and due process, the standard against which the SEC seeks to measure defendants' conduct is the statute itself, the language of which defendants and all others even arguably involved in securities transactions plainly have had notice. The SEC is looking to make the same argument in the SEC versus Ripple. It is for the courts, not the parties, to determine whether particular conduct falls within the scope of the statute. Indeed, the court rejected the defendant's fair notice defense at the motion to dismiss stage despite acknowledging that the lack of binding authority constructing the term dealer. In Ripple's case, binding authority constructing the term investment contract has existed since 1946. Hogan says burden is on the SEC. While Ripple Labs prepares a reply to the SEC's letter, XRP community attorney Jeremy Hogan took to Twitter to offer his analysis on the case, which marginally helps the SEC's position in its motion to strike Ripple's fair notice defense. It was in a very different stage of litigation, and the standard is completely different than the SEC versus Ripple case, he said. In the Fife case, the defendant tried to argue fair notice in order to dismiss the lawsuit entirely and failed because the burden is very high on a party moving to strike a pleading. Fife can still raise it as an affirmative defense later, and I expect they will. In the Ripple case, it's the SEC that is trying to strike the affirmative defense of fair notice, and it has the high burden to meet. The general idea in modern courts is that the decision should be made after looking at the evidence unless there's no plausible way of winning, he explained. The lawsuit allegations are disturbing. The press release made the following claim about the conflict of interest bordering on corruption. Former senior SEC official William Henman received millions of dollars in compensation from his former employer, Simpson Thacher, while helping guide the SEC's regulation of cryptocurrencies. The press release went on to say that other officials at the agency also had severe conflicts of interest. Additionally, it claims Mark Berger, the SEC Enforcement Division leader who sued Ripple Labs, also left the SEC for the same law firm. The SEC sued Ripple Labs in December of 2020 for allegedly issuing XRP as an unregistered security. The company has since claimed that the SEC does not have clear rules about which cryptos constitute security and which don't. Both Bitcoin and Ethereum have been designated as not being securities. For example, the suit says former SEC Chairman Jay Clayton may have had conflicts of interest. He declared Bitcoin was not a security, then joined cryptocurrency hedge fund One River Asset Management, which only worked on Bitcoin and Ether. Several other officials mentioned in the press release also worked for companies they were formerly regulating. What this could mean for XRP. So far, the lawsuit does not state which of the regulators may have broken exact rules if the allegations are true. Moreover, if true, the SEC could be forced by a judge or public opinion to close the lawsuit against Ripple Labs. But one thing is for sure, it does not look suitable for the agency. One reason is that certain banks might be more inclined to use crypto if it is less controversial. Ripple Labs wants them to use XRP and other products for money transfers. If that happened, XRP could move substantially higher. This has been one of the main criticisms of XRP so far, at least in the US. However, Ripple Labs points out that its on-demand liquidity, ODL, product's payment system has been used extensively overseas. Its website says that hundreds of financial institutions use its RippleNet product to provide a better payment system. RippleNet connects users to these institutions worldwide, aiming to make money transfers more efficient. Ripple Labs now says that ODL customers today can now access over 20 countries around the world for their payment needs. It claims its international transactions in ODL have grown more than 25 times over the past year. This new lawsuit will put more pressure on the SEC and perhaps even Congress concerning the regulation of cryptos. It may lead to a resolution of the existing case over whether XRP is a security or not. If this occurs, the crypto can seriously benefit as its controversy ends. That's it for today, guys. We will see you next time. Until then.